Okay, students, welcome to another week of lectures. This week we're going to be doing civil liberties, freedom, government, and government authority and tension, chapter 4 of your textbook. This week we're going to be going over like civil liberties and the Bill of Rights and how having those liberties in your Bill of Rights are there to protect you from what government can't do to you. You'll have a little more understanding of the difference between civil rights and civil liberties, whereas civil rights it talks about what government has to do to protect you, right? And so then you have civil rights where I just said to the protections of the Bill of Rights. And also develop a strong sense of purpose of each of the first 10 amendments. And so that's where your Bill of Rights are. Those where your liberties stand. Really, those first 10 amendments are there to protect you against a tyrannical form of government. And when we talk about this, and as we go through this lecture, we're going to hit on the origins of the Bill of Rights. There were some who wanted a Bill of Rights because they were scared of this having that centralized government would somehow turn tyrannical. And so there's those of us there was those of us in our society at the time who thought having these Bill of Rights would protect from this concept of a tyrannical government. Now remember, we just fought a Revolutionary War for our independence. And the goal of that was to the goal of the early Americans being free of the crown, the British crown and parliament and all those taxes, was the idea that it would give them their liberties and they're not forced to worship in the Church of England. Okay, and that's what a lot of it was. It was about the early Americans having rights to life, liberty, and the pursuit of happiness, as Thomas Jefferson said. There were those who were opposed to the Bill of Rights, those like James Madison and Alexander Hamilton, for all those who like Hamilton. And because Madison and Hamilton felt that with separation of powers and checks and balances because of the three branches, and then having the state, the county, and municipal governments in place, those would protect our individual rights from a government of tyranny. Well, you had one, George Mason, who has a university named after him, George Mason University, who was a signatory to the Constitution, the Declaration of Independence. And he argued that he would not sign unless there was a Bill of Rights. Now, when we talk about the Bill of Rights, we're talking about these 10 amendments that were put there to protect you from government and allow you to have certain rights, the freedom of speech, right? And so when we're talking about our Bill of Rights, we're talking about our liberties, things that give us a right to say what I want up until a certain point. Worship where I choose to worship, right? I have a right to remain silent. I have a right to a speedy trial. So we're gonna talk about some of these things in this lecture today. So please be prepared. This chapter, it's a little different than the previous chapters because we're going to kind of delve into a little more into the Constitution and things that we normally really don't talk about in our everyday lives. So when we talk about the incorporation of the Bill of Rights, it was for the application of Bill of Rights to state and local government. Eminent domain, if you look at eminent domain, it's a provision that you find in the Fifth Amendment, and it requires government to provide compensation when it takes private property for public use. A good example of that is the 210 freeway that at one point, the 210, I believe, did not go any further probably than, and if you guys don't know, I'm going to explain to you. The 210 freeway runs in the northern part of Los Angeles. It goes through Pasadena. It takes you out to San Bernardino. Well, at one point, that 210 freeway did not go through it. I believe it stopped at the 57 freeway, which takes you down into 57 South, takes you into Orange County from the Inland Empire. Well, there was a group of people in Claremont, California. And if you don't know Claremont, Claremont is a place where you have the Claremont colleges, and the Claremont colleges are very prestigious colleges. There's 5 of them, and they're very prestigious, very hard to get into. And the people of Claremont did not want the 210 to go through there because it's literally cutting through Claremont. And so for years, the people of Claremont, where you have people with a lot of money, fought the state. The state argued eminent domain. The people of Claremont were arguing it's their private property. The state ended up compensating those people. You have the 210 freeway that now goes through. No matter how much money these people had, the state argued it's eminent domain. We should be able to run a freeway through. So it makes, it alleviates congestion on the 10 and the 60 freeway and the 91 going east out to San Bernardino and Riverside. And so you'll see these type of issues where people will argue, well, I have a right to own my land. Well, you do have a right to own your land as long as it doesn't impede with the public good. So if your land is for the public good, then guess what? You have to sell the land. And when we talk about the 14th Amendment, you have this thing called due process. Due process gives you have due process of law. So if you have rights under the Constitution. And when we're talking about due process, we're talking about this idea that your rights, our rights as Americans, must be resolved based on the rules that are set about. Okay, so everybody, there are rules, there's laws in place, and you have a right to due process under the law. So you have a right to the rules. They can't change rules and in the middle of your trial, so to speak, and implement rules that would be to your detriment. Whatever rules are in place, and everybody plays by those rules. And so if you have a prosecution or a complainant, and then a complaintee or a defense, the defense has a right to due process. Okay, and it's going to be on the burden. It will be on the prosecution to bring about. So it'll be on the prosecution to bring about charges, to bring about that guilty verdict. And so the burden of proof will always be on the prosecution. Okay. So when we talk about selective incorporation, the Supreme Court basically gave incorporated specific liberties deemed absolutely necessary in a free society. So the Supreme Court gave about certain liberties that they deemed absolutely necessary in our system of government, which you would find them in your Bill of Rights. So this is important to you. This is important to us. So of course, everybody knows about the First Amendment. When we talk about First Amendment, we talk about political dissent. Now, back in early, when John Adams was president, you had John Adams had brought about some acts, which were the Alien and Sedition Acts, which if you read the Alien and Sedition Acts, you know, it basically, if you complained about the president, then you could be charged, and which was sedition, right? Some people argue on January 6th that was sedition. And I would agree with January 6th being a seditious act. I don't know if saying John Adams wasn't necessarily the best president uh, is a seditious act. But when we talk about political dissent, the clear and present danger test requires that the government demonstrate that banned expression poses a definite or immediate threat to peace or national security. So, but the government has to prove that. Again, it goes back to due process. You have rights. You have rights to say certain things. Now, you can't say bomb in an airport. You can't say fire in a crowded theater. There's certain things you can't say. You can't even say, I'm going to kill you, because that is not, you don't have a right to make threats to someone's personhood, their life, okay? When we talk about pornography, pornography and offensive speech, this is, you have a right to use certain words. And that's a hard, as an African-American, there are certain words that, you know, Black people will say, we can say us ourselves, but others cannot say these words. And, but in reality, they really can. They have a right to say these words. When we talk about fighting words, they're derisive, insulting, offensive words that inflict damage on other people and are therefore not protected by the First Amendment. So if somebody gets hurt, look, if somebody calls me the N-word and they're in their car driving down the street, that's really not, those are not fighting words. They're driving their car, they're going down the street. People, they have a right. They really do. They have a hate speech, hostile expressions based on race, ethnicity, gender, LGBTQ identity, or religious preference. But again, these hate speech, it is hate speech. And if somebody gets hurt in the process of hate speech, then that's where it is. But if somebody says a word and nothing happens, it is hate speech, but nothing happened. People do have a right to say for certain things. Now, if you're in a commission of a crime, if I'm in a commission of beating somebody up and using hate speech, then that becomes a hate crime. So if I'm fighting somebody and I start beating them up and start using the F word, not the FU's, CK word, I'm talking about the one that talks about sexuality, F word. If I use that word in that manner, then there could be a bit of and I'm kicking somebody and I'm saying that word, that's a hate crime. Now, can somebody say, let's say I'm fighting somebody who has a sexual preference that is not straight, and I don't use that word, and I don't know if they are, that it's going to be harder to prove that that's a hate crime. So the words you use will let people know. If somebody's beating me up and then starts using the N word, yeah, it's a hate crime. Or if they just call me an a-hole, that's not a hate crime. And I'm sorry, there's going to be some language brought up in this. It's within context of the classroom and the lecture. When we talk about things like freedom of the press has a right to print the truth, okay? Be aware of that. The press has a right to they have a right to print the truth. They do. And if the truth does not portray whomever in the best light, then okay, that's okay. That's okay. I mean, if any of us did, if I'm embezzling money from the institution, and the media reports this story, guess what? They have a right to report that story. Now, if it's not true, this is where libel comes in. But let me go back to prior restraint. It's a usually impermissible government regulation that prevents the publication of printed material. Government cannot. Normally, government is with government can't stop a newspaper from printing an article. Joe Biden has not had a great press lately, especially with Afghanistan. Joe Biden does not get to tell the Washington Post or the LA Times not to print anything negative about Joe Biden. Look, we can all agree Afghanistan and the United States and pretty much the Western countries and the United Nations and everyone pulling out of Afghanistan was probably not the most orderly withdrawal. And so therefore people got hurt. People jumped on planes and were flying off planes. And it was very bad. But Joe Biden doesn't have a right to tell them not to do that. The media is there. The media is what we call I call the media the fifth estate. It's not the fourth estate. It's the fifth estate. The bureaucrats who are running our government, who run the day-to-day operations of government, are the fourth estate. So when we talk about libel is the publication of written material that damages a person's reputation, and it's not true. So libel has to be in writing. Slander, which is different, is me saying something negative about somebody. It's harder to prove slander than libel. Libel is easy to prove because you have it in writing. I have it all right here in the writing. So I can prove to you what Professor Callahan was saying about me was slander, because he literally wrote it in Canvas in a what do you think where we all could see it. And I now have a screenshot. Now, if you go and tell my dean that I was bad mouthing you to another, let's just say even say it to another student, and the other student might be your significant other, that's going to be harder to prove, because I can say, well, that's their significant other. They don't like me. They're not doing well in the class. This is not true. And so it then becomes my word against your word, or your significant other word, your significant other's word. And so that's going to be harder to prove. And slander is much harder to prove than, and just remember that when it comes to slander, it's much harder to prove. Libel, again, it's in writing, and it does damage a reputation. When we talk about, you can't talk about you can't talk about our Bill of Rights without talking about criminal justice. Criminal justice is very prevalent right now because of the fact that we are living in a time where we're having people protest. There's a lot of protesting, police brutality. We have people protesting mask mandates. Right now, we're just a nation that loves to protest. When we talk about protesting, when we talk about our Fourth Amendment, we're talking about search warrant. The search warrant is a legal document that allows law enforcement to search a person, their home, their business, their car. But the search warrant has to have it in writing. It has to say it, like, it says they can search your home, but it doesn't say your business, then they can't search your business. So it has to cover a wide latitude of your personal belongings in order for them to search it. And you have a right to say no if they don't have a search warrant. Somebody comes to your house and they knock on your door and say, "Can we search your property for?" You say, "You have a search warrant?" "Nope." "Then no, sir, you cannot. You need to go get a search warrant." When we talk about probable cause, it's a legal requirement that there be evidence indicating guilt, that then indicating innocent before the law enforcement can act. So sometimes you get pulled over, and some of you will say, they will say, "Well, we have probable cause. We have enough probable cause to believe that you have something illegal in your car." And so that's going to be a hard one for you to push against. But guess what? You can get an attorney to fight it if they do search your car, end up arresting you for having something illegal in your car. But if you have something illegal in there, it proves the point of probable cause. It proves that they really did. When we say exclusionary rule, this is a civil liberties protection that protects the use of evidence gathered in violation of the Fourth Amendment. So you'll hear attorneys in the courtroom say, "We want to exclude this because when the police entered the home, they did not have a search warrant." And then the other side will say, "Well, we had enough probable cause." And then they'll try to explain and argue. And then it'll be up to the judge to exclude it. And so sometimes the judge will exclude it, and then the prosecution will have to find other ways to prosecute this person. So that means they can't use that whatever evidence they might have found in that discovery. Then we have racial profiling. There's different types of racial profiling. We have debated racial profiling based on race. When we stop and frisk was stopped in New York because of racial profiling. What they found under stop and frisk, most of the people that were being stopped and frisked were actually Hispanic males, but they found that white males had more illegal paraphernalia on them, even though they were getting stopped and frisked less. So, and it kept going on for years and years. So black and brown, mostly brown men, and then black men were getting stopped, but they were finding white men had, when they were stopping them, had a higher rate of illegal paraphernalia. So New York and most places in our country stopped doing stop and frisk because it was leading to a problem with communities of color and law enforcement. And but another racial profiling is how we profile for terrorism, what we deem to be terrorists. And if you look at the little cartoons, most airports stand by no profiling rule, but then you see them pull certain people out. Chief, and UFO landed in the parking lot 10 minutes ago. Then stop that lady for questioning, and look who they're stopping. Not the alien in front of her, but the older lady behind them. Office of Homeland Security's new color-coded racial profiling system. White, you're all right. Yellow, must be mellow. Brown, better stay down. Red, good as dead. Black, better get back. Arabic, most not actually a color, but you're still screwed. And so whoever did this, looks like they did this back in 2002 after 9/11, and people who we thought were Arabic or of Muslim background were stopped a lot. And we also had some people who were Sikhs who wear turbans. We thought, and some people thought they were Muslim, they were not. It's important that we learn about the other groups of people and their dress and their attire and what they believe and not believe. But even if somebody's a Muslim, doesn't mean they believe in terrorism. And we also have domestic terrorists in our nation. In fact, the FBI has put out, I think for the past, it has to have been for the past 10 years, most of our what we deem to be terrorism is homegrown terrorism. It's being homegrown in America, and they're not people of Middle Eastern descent. Actually, they're white supremacist groups. That's the biggest threat to our homeland as of right now, to our democracy, are white supremacist groups, Oath Keepers, KKK, which I'm still surprised is still around. Neo-Nazi groups, all of those, Proud Boys, all those are considered, even though threats to our democracy, according to Homeland Security, Department of Homeland Security, and the FBI. Cool. When we talk about investigations, Fifth Amendment, you have Miranda rights. Miranda rights, and I'm going to just go ahead and read this. It was a case out of Phoenix, Arizona, where the suspect, Ernesto Miranda, a 22-year-old illiterate homeless person, had kidnapped and raped an 18-year-old woman while in police custody without an attorney. Miranda confessed to the crime. And prosecutors used the confession to convict him of rape and kidnapping. Miranda appealed his conviction, in addition to reinforcing the rule that suspects can have attorneys present during interrogations. The Supreme Court ruled that the law enforcement agents are required to inform suspects of what they have, what we call a Miranda rights, like what are you arresting these people for? And so it's important to know your rights. And if you get arrested and they don't read your Miranda rights, you're going to be lucky you're going to be very lucky to walk away. Then you have trial, which is the Sixth Amendment. You have a speedy trial, right to a trial by impartial jurors. If you looked into the South, especially places like Mississippi and Alabama, you would you had these cases where you had people you would have jury trials, and in the 60s and the 50s, especially when there was Black people being prosecuted. They were being prosecuted by all white juries. That's not going to be a jury. That's not going to be impartial, especially in the South during Jim Crow, and especially if the victim was a white woman. Just not going to get an impartial jury. It's those were concerns, and so a jury has to be impartial. That's why when you go to jury duty, they ask you all these questions, and some people get out of it. Some people will say things like, I believe in the death penalty. I hate drug dealers, and if the defendant is a drug dealer being accused of drug dealing, guess what? They're going to strike. They're going to remove you from that from the jury pool. They're going to tell you no. And a lot of us don't like doing jury duty because they feel like it just doesn't it doesn't work. It doesn't work with their work schedules, their home schedules. Some people don't get paid, and so it's a lot of things going on there when we talk about jury trials. Sitting on a jury, having to be on trial. Some people just don't even want to make that decision have that control over somebody else's life, because some people just don't like. They just don't want to participate, and there are some religions who are exempt from jury duty. If you're a Jehovah's Witness, you're exempt from serving on a jury duty. So you can use a religious exemption. And that's just one religious group that does that. I'm from Pennsylvania. I had never seen an Amish person sit on a jury either. So I believe they exempt themselves from that too. So when you say peremptory challenges, the right of each side in the legal case to discard a set of number of potential jurors without needing to express a reason for doing so. Now, you saw this a lot. You do see this a lot in trials. You see this when people, especially when it's people of color, and I'm gonna speak very real with you. You'll see one side will look and say, we probably, if the person is a person of color, they're probably gonna say, we want to get rid of that Black guy because he's probably gonna side with the Black guy. But you also see this with white people too, especially when it's something that has to do with crime, or they feel like the white man will not like the Black guy. So let's remove that older white man off because he's going to automatically say the guy is guilty because he's Black or he's Hispanic. There are many reasons why lawyers will have people removed, and race is one of them. Gender, things that you can look at people and tell. You will try to have them removed from the jury pool. Then you have punishment, which is our Eighth Amendment. The Eighth Amendment talks about cruel and unusual punishments. Punishment cannot be cruel and unusual. Bail cannot be. You're not supposed to have access to bail. But let's be clear. There are some people whose bail is at $500. But if you are a 18-year-old kid who got caught stealing a Snickers at the store or whatever, and you're sitting in Rikers Island and your bail is $500, but your mother has like 5 kids to feed, where is she getting the $500? Even that's too much to let this young man out on bail. So he ends up sitting there possibly for 2 years because the trial and the court system is backlogged. There's so many cases and it's backlogged. And even though you have a right to speedy trial, you can, even though you have a right to a speedy trial, sometimes the backlog is so bad that you're encouraged, for the sake of a lesser fine or a lesser term in jail, to allow justice to take as long as it needs to take. so to speak. I saw this when I was in law school. I was sitting in I had to go sit in a courtroom, and it was only I think traffic court, but they were so backlogged that the bailiff encouraged everybody in the room, to uh, not take the speedy trial because the judge was so backlogged. And if you want your fine to be lesser than what the law says, because the judge can reduce the fine a little bit, I suggest you tell the judge to take as long as he needs to, as opposed to asking for a speedy trial. And everybody in that room told the judge to take his time because they were getting their cases either dismissed or the fines reduced. So that worked in their favor, and that sometimes is justice. We're big on cruel and unusual punishment, not having cruel and unusual punishment. The Taliban said they're back to chopping people's hands off if you steal. We would call that cruel and unusual. There's some of you might even argue those who are rapists or molesters should have certain body parts probably severed. Well, that would be considered cruel and unusual, even though that person has probably done something that's even worse. It's still cruel and unusual. The state itself cannot do an eye for an eye, in the sense of, just because somebody might have raped you doesn't mean the state can condone the person who raped somebody to be raped themselves. State sanctioned crimes have to be will be taken, but it can't be cruel and unusual. And the United States, some people say the death penalty is cruel and unusual. Some people will say that. Some people argue that they're against the death penalty. There's many myriad of reasons why some people are against the death penalty. Myriad reasons why. But there are also reasons why people are in favor of the death penalty. Some people think the death penalty will curb crime. What we have found is it doesn't. So we need to come up with better solutions and better plans. When we talk about privacy, personal autonomy, sexual relations against consenting adults is also an issue. You have a right to privacy. When we talk about, there's been cases like Bowers versus Hardick. The latest was Lawrence versus Texas, where two men were having sex. They were charged with sodomizing. And that was as late as 2003. Now, marriage equality is the law of the land. So you can't prosecute people based on who they have sexual relations with, or they choose to have sex with. As long as adults are consenting, it is none of your business. It's none of my business. We need to stay out of people's bedrooms, boy. Americans love to be in people's bedrooms. We need to stop. That's just one area we need to stay out of. And then you have right to die. Right to die is it's a very controversial. And some states are in favor of right to die. California, and let me be clear. When we talk about right to die, people have a right to refuse medical treatment as long as they're in their right frame of mind. And when we talk about right to die, it's not just somebody says, I want to die, and then they just go and die. No, you have doctors who say this person is terminally ill. There's no way, there's no cure. This person will ultimately die. And some people want to die with dignity. Now, I'm not for or against. It's just a very interesting topic to discuss. And so the Supreme Court has ruled that people have a right to refuse treatment. And so that I guess gives them their right. Now there's, like I said, some states have California being one has given. I think the young lady who was real sick and her family had to take her to Washington. So California went on, because in the minds of most Californians, we all knew the young woman was going to die, and her name escapes me right now. But her family had to move to Washington. Her husband, her parents had to move to Washington, and then she ultimately passed away. And but California passed a law that has given people the right to die if they're terminally ill, terminally, and that's the key. People do take their lives, so, and that's called suicide, and that's something totally different. Sometimes it's, a lot of it does do with mental health, and that's a different topic to discuss. And then we talk about privacy, abortion. Right now, abortion is a very big topic because you have states like Texas that have passed a 6-week law or 9-week law. Florida, there's other states that are trying to do the same thing. Abortion, again, is another hot topic, little play on words, but it's serious. Some people believe life starts at conception, especially if you're Catholic, and others evangelical, like very religious. And if you're very religious, or even religious at all, you believe that. You believe that life starts at conception. Now, others have said that the science, and just like the science community, have said that life does not start at conception. But again, like I said, I'm not going to sit up here and argue on the pros and cons of abortion. It's an issue of privacy. That's pretty much it. And like I said, it's very hard. I personally don't believe people have abortions to have as a form of birth control. I've heard that argument. I really believe that when women do this, it's something they take very seriously, and there's a myriad of reasons of why they do it. Okay, I just want to just put that out there, because we tend to, as a society, take the most extreme, minute numerically, most extreme, minute reasons to make arguments. And a lot of times when people have abortions, may it be through rape or through not having enough money. And this whole argument that people shouldn't just have sex. Well, they shouldn't have sex if they can't afford a baby. No, we should not be telling people what they should and shouldn't do with their bodies. And I would say this to the men who are listening to this: when we get with women in our relationships, and women too, you guys need to sit down and talk, have conversations about these issues like abortion. Really have that conversation, because if you get with somebody who believes in abortion and you don't, that might be the deal breaker. So people need to learn to communicate. A lot of us don't, and I don't think we do communicate, especially when it comes to things like sex and abortion and religion, and have these conversations with people you're in relationships with, because if you don't have these things, if they're deal breakers, you don't have these things in common with them, then maybe that's not the right person for them. So just think about that. And that's pretty much the lecture for this week. I want you guys all to have a safe week. Take care. Thank you.